Hello, everyone. It's Francis Widdowson here. I just wanted to do another video to provide some context and background to the arbitration decision. I realize that I've done a number of videos, but it's a very, very complex area. And I realize that people just going into the arbitration decision, that's going to be a very difficult process. So I've already done two videos. One was on just a very, very high level overview. The second one was looking at the four levels that resulted in the arbitration decision. So the arbitration decision being the highest, sort of the most important document, obviously, but then we had the submissions of MRU and the MRFA, final submissions, very, very important. Then we had investigation reports and other exhibits, what's called exhibits. And then we had the universe of documents, which were, thousands of documents. So anyway, so I provided those two videos. Now what I'd like to do is share my screen with you to show a couple of other posts that have been put on the wokeacademy.info site. And when I share my screen here, what you see here is, as I mentioned, you just go up to the top here, that is the website, www.wokeacademy.info. As I mentioned, I did one video for the arbitration decision, one video explaining that diagram with the four levels, and then I've done two additional posts. One is kind of giving you the documents that are involved in the four levels, which I'll take a look at now. And then finally, what I've done is I've provided some excerpts of the arbitration decision, those parts of the decision which are the most important, because it's 300 pages. A lot of the materials concern these what's called procedural grievances. The arbitrator just didn't listen to those arguments at all. So we're pretty much going to just move into the substantive grievances, which are to do with the discipline. So anyway, so what I'll do first is I'll go into the four levels of the Francis Widdowson case. This is what I talked about in the last video, explaining those four levels. And what I've done in this posting is I've provided you with the documents that are associated with the second level. So you already have seen the first level, which is the arbitration decision. I've gone through that a lot. That's available on the Canley site, and it can be linked to here. But then we have the other level 2 documents, which were the most important documents upon which the arbitrator largely based his reasoning. Now, he could have taken into account other exhibits, but he's going to rely mostly on what was provided in the final submissions. And these final submissions, when I click on that, you can see these submissions. So there is here, to get into these documents, what you do is you just click on this chevron. This is the MRU final submission. You click on that chevron, you can go into the presentation mode. And what it does is it gives basically MRU's arguments for why it thinks that it's justified that I should have been terminated. So I'm just trying to get out of here. So that is MRU's document. And then one of the important things that I did in these two kind of things here is I'm showing that this was paragraph 155 in that MRU submission. And this is now their case with respect to the Hope investigation of Renee Watchman's complaint. And as I explain in this other area here, that this was not the original case that was made in the Hope report. Hope actually had 2 other tweets and a Facebook post that he thought was harassing and creating a toxic workplace. So that's just giving you an indication of how MRU is kind of a moving target with respect to their case. And then we have, again, if you go into the Chevron here, you'll see the MRFA, which is my union's closing submissions. And there's, 164 pages with all sorts of different arguments that are being made. I think that was a pretty good submission, actually. And then what it does is it also provides the replies, right? So when it says here, you can, MRFA's reply to MRU's final submission is available here. If you click on that, you can get the MRFA reply. And by the same token, here you have the MRU's reply to MRFA's final submission is here. So those links are all provided in this level 2 kind of documents that are provided with respect to level 2, which are shown in this post. Level 3, right? So this is lower down on the chain. It still would have mattered for the arbitrator to look at those documents, but they would have been less significant than the final submissions. And there were 108 documents from MRU, 195 from the MRFA. And what I did at the time, and I think it was October and December, is that I did an analysis of the 5 investigation reports for the Canadian Association of University Teachers. And the first one was the differences found in the 5 investigation reports. And if you just, I'm not going to go into the actual presentation at this point, but I identified various procedural issues of how the reports differed from one another. I also looked at the substantive issues, the most significant substantive issue being a separate analysis of the threshold for harassment that was used in the 5 investigation reports. So that's a major problem with the investigations that occurred, is that the harassment threshold, so what you would need to have done to have a finding of harassment, that threshold was much harder to meet in Stephen Eichler's investigations when he investigated the complaints I made than the Hope investigation. And that was the Renee Watchman complaint. Hope's threshold was very, very low. So even if I didn't have a tweet that was directed at any individual, it was just satirizing the Mount Royal Anti-Racism Coalition, which was an anonymous account that was part of the mobbing that was going on about me, he still found that was harassing, which would never have found to be the case in the Eichler investigations. But anyway, so those are very interesting documents that I compiled myself to give to CAUT, and that concerns those 5 investigation reports. If you are very interested in the investigation reports themselves, I have provided all the investigation reports in one place. So we see the Hawkins investigation report, that's number 1. The Rents investigation report, which was the Gabrielle Lindstrom complaint. The first Eichler investigation report. One thing that's interesting about this, these are all obtained through Freedom of Information, so they have redactions. In this report, the 17 appendices, which were about the specific findings for each of the 17 colleagues that I complained about, those were withheld, completely withheld. And I only saw them in arbitration. And I'm just waiting for those to be compiled by the labor board before I start, getting involved in that nitty gritty of those things. Then we have the second Eichler investigation report, which is found to be frivolous and vexatious. And then finally, the Hope investigation report. So for people who are so inclined to see what those actual reports look like, that's been provided to you in that particular area, in this 5 investigations report area. And then level 4, which are documents and recordings that were not entered as exhibits in the arbitration. So they existed, but for some reason it was decided that they were either not relevant enough or they were too cumbersome to deal with. Anyway, I did a lot of recordings myself, from about 2019 on to 2022 or so. Anyway, one of the most interesting of the recordings that I have were the recordings of the Jeff Hope investigation meetings on October 20th, 2021 and October 27th, 2021. This concerned the Renee Watchman complaint. And reason why I posted those 2 recordings is I find this is the most bizarre of all the findings that were made against me. I spent 6.5 hours explaining all these ridiculous things that Renee Watchman was complaining about. I spent hours talking to Hope about this, and then for him to come up with the investigation report that he did, that is amazing. So I really do find, especially this second one on October 27th, the last couple hours of that, where I explained over and over to Hope about how I was being mobbed, why I was using satire, and then for him to come back with this, his findings were this one Facebook post and these 8 tweets were somehow, because I demeaned the viewpoints of people like Renee Watchman, this was harassment according to his view, and that would not have risen to that level in any of the other investigations. So, as I mentioned, Hope is an important case, the investigations, because his understanding of harassment, if that's gonna stand, it's gonna mean every single professor who's using social media, it's got to be really worried, because they could say something that demeans the viewpoint of a particular prized individual. And that's what happened to me. Anyway, so that is this post on the Woke Academy site. It's the 4 levels of the Francis Widdowson case. And those 4 levels, I've just provided the documents, to correspond with this diagram. So that's just to flesh out that diagram with some documents. The final post that I have done so far, the arbitration decision, is I provided some excerpts of the arbitration decision, just because I know that it's a very difficult decision to follow because it's so long and there's a lot of things that really are not at issue anymore. So what I've done is I've provided what I consider to be the most significant excerpts, and there's 3 significant excerpts. Number 1, the arbitrator Jones is reasoning concerning why he overturned the discipline of the 2-week suspension and replaced it with a letter of reprimand. That's 9 pages, that reasoning. Number 2, his reasoning concerning rejecting the termination, and that's when you scroll down. I provided some additional documents there, but it's the reasoning concerning the termination. So why did he decide to overturn the termination? And then the third area, which I talk about here, is his reasoning concerning the non-reinstatement. So arbitrator Jones decided that I should not be reinstated at Mount Royal University. And I provided that part of the arbitration decision, which is here. So arbitrator Jones's reasoning concerning non-reinstatement, it's 4 pages long. So that's the overview of what those documents are. Again, 3 excerpts. One concerns the suspension, the reasoning about that. The second concerns the arbitrator's reasoning concerning the termination. And the third is his reasoning concerning the non-reinstatement. Okay, so what I'm going to do now is I'm just going to show you these, you can enter into them. Again, you go into this little chevron on the right-hand side. That will take you into presentation mode. And you'll see here, right, grievance 4, 2-week suspension without pay. I've just added that as, square brackets to say what that is. And what I've done is highlighted some of the important parts. So, and an important one that we're going to be talking about is that the arbitrator argues that there is no evidence to indicate that the employer ever suggested that social media communications were somehow exempt from the personal harassment policy, the Code of Conduct, and the Occupational Health and Safety Act. So that's an example of something which is very, very important, which I am going to talk about right now, because it is very surprising that the arbitrator stated that, because at 3 times in the arbitration hearings, he was alerted to the fact that that was not true. Like, there is evidence that MRU had a policy in 2019 to not have its harassment, code of conduct, etc. policies apply to personal social media accounts. And CAUT stated this in paragraph 121 when it talks about this situation that happened when Milena Razankowska, who is a professor at MRU, she tried to file a complaint against me in 2019. And MRU told her that these policies did not apply to social media. So that was provided to the arbitrator in the final submission by CAUT. And also it happened in the arbitration hearing where the CAUT lawyer was cross-examining Stephen Eichler, who was one of the investigators. And they're talking about here that Eichler, and these are my notes. I took very, very detailed notes. I tried to do it verbatim. I tried to type really, really quickly and have a verbatim as good as I could do. I obviously left out some things. It's very, very hard to type that fast, but I just tried to just write everything down that I possibly could. And Eichler says here that he did receive a specific email from Razankowska saying that the workplace did not extend to social media. And that's why Razankowska was found not to have harassed me, is because it was called officially induced error, because she was given that information by MRU, which it then changed in October 2020 when it decided to accept Gabrielle Lindstrom's complaint about my activities on social media. This was also the case again, the 3rd time in the arbitration, when Provost Evans was cross-examined by the CAUT lawyer. And Evans was the dean who Razankowska complained to. And so the dean, when she was dean, she was very well aware of this and did admit finally, although there's a bit of obfuscation that happened, because she was trying to say that it was just because it was an MRFA Facebook account, that's why it wasn't accepted as a complaint. But it turned out, no, there was some public social media posts on Twitter that the MRU decided not to investigate. So this is a hugely important area. 3 times that the arbitrator never registered with the arbitrator. So, and this is important because it states in the collective agreement that you cannot be punished for violating a rule that you didn't know existed. And there is evidence that how no one could know that that rule existed, because the rule was different in 2019 than it was in 2020. And that raises the question as to why MRU decided to change its policies in that 1 year. Specifically, I'm sure it's, has no relationship to it when I was complained about by Gabrielle Lindstrom. And we can speculate as to why that change happened. So that is the, there's a lot more in there, but I thought I would extract one of the most important things within that discussion of the 2-week suspension that Arbitrator Jones provided. Then we have the document about the termination. And you can again go into that chevron there. And again, grievance 9, termination. And I have highlighted some important areas of this reasoning that the arbitrator provides. I have extracted a few things, specifically when the arbitrator on page 281 talks about the termination letter, and you can actually get the entire termination letter if you click on there, when he talks about the grounds. And this was an interesting thing that happened in the arbitration, is that the termination letter, MRU was claiming that there were 3 grounds for discipline, which was this finding of harassment, the frivolous and vexatious complaint, and then contributing to the harassing and toxic workplace. This was all investigated. So, you know, fair enough. I totally disagree with the investigations, but you did have, I was able to respond to these things. But then we had these 12 items that were added, and MRU never put them to me. Like, I never had a chance to respond to those 12 items, but it was claimed that they're not grounds for discipline. They are the factors for assessing the appropriate disciplinary measure, which was termination. So they were able to terminate me on factors that had never been put to me. And as we'll see shortly, this is quite significant. Anyway, because the arbitrator on page 288 and 289 says that these 12 factors in assessing the appropriate disciplinary measure were either inaccurate, almost all of them were either inaccurate, not proved in the arbitration hearing, or not worth of being considered in a university that values academic freedom. So all of this, these claims by MRU that it never violated my academic freedom, well, because it decided to terminate me on these factors that were not worth of being considered in a university that values academic freedom, seems to me kind of calls that into question. And so what I've done is I've extracted this part of that decision on page 288 and 289, where he talks about this, and he talks about these 12 factors, and he talks about items 3 and 4, and that was to do with meetings that I was claimed to have disrupted, and those were refuted in the arbitration hearing. Items 1 and 2 about complaints, right, that were made, and it turned out that those complaints were about my views and not about my social media activity. Item 7, it's about me being engaged in harassment and creating a toxic workplace environment, but toxicity is related to a broader range of issues than the harassing social media communications. And this is shown by the breadth of the allegations contained in the complaints by both Lindstrom and Watchman. And that is very significant because those complaints, the breadth of them, especially Watchman's complaint, shows a complete hostility to academic freedom. So and this footnote here, 351, he does find that they were right to perceive Dr. Widdowson did not recognize the harassing nature of her social media communications or having any remorse for her conduct. So this was items 10 and 12 of this termination letter. This is the factors. Anyway, so what I've done here for you is I've just kind of summarized what the arbitrator was saying there, and I've provided a screenshot of these 12 factors that MRU added on, and you'll notice that it's got different colors in the numbers. The blue color is when the arbitrator found that these had been disproven or they were inaccurate and so on. So he specifically mentions those items. The yellow 7, 10, and 12, these are the items that the arbitrator says that there was some, there was some evidence for this, although with 7, he said that they didn't take into account the fact that others had created a toxic work environment. But 10 and 11, he said, yes, you never did take responsibility and you have not indicated any remorse. And then you have the pink items, which are things that he didn't mention, the arbitrator didn't mention specifically. And I do have evidence that shows this was false. Number 5 was false. Evans evidently claims that I said this in this December 13th, 2021 meeting. I have a transcript of that, which the arbitrator was privy to. That is not true. This is a ridiculous one, number 6, which I assume is that the arbitrator is saying it does not belong in an academic institution. Because how am I supposed to be responsible for the resources that are spent by MRU? Like, it's up to them to do that. And then finally, I found in my continued conduct is harm the reputation. Hope did refer to reputation, but he didn't make that conclusion. He just said that it was possible that the reputation would be harmed. And then this here, number 11, that I thought that a 6-month sabbatical, that do not appreciate the seriousness of your actions. My argument was that since I had been taken for 6 months away from my sabbatical, that I should get another 6 months so that I could work on my manuscript and so on, because I had been pulled through all these investigations, that there was no rule that was promulgated. So that was the reason for that, which was mentioned to Jennifer Pettit in a September 2021 grievance meeting. Anyway, so that is explanation for that. And then finally, we have the third excerpt, which is about reinstatement. And just going into this presentation, it's about the remedy, right? And dismissal is not appropriate. So he's already said that I shouldn't have been terminated. So, how is he going to, determine this remedy? And he decides that my continued employment relationship with MRU would not be viable for the following reasons. And he gives 9 reasons for why this is the case. And what I've done is I've taken that area and I've provided it below here, and I've just numbered those 9 bullets on page, I think it's 291 and 292. That's in the arbitration decision. And what I've done is I've responded to each one of these claims, right? Because I really, and this is going to be the subject of the appeal, but I really do not think that these are valid reasons that he's given. And it's a complete failure to take into consideration the fact that many of these people he's referring to have no respect whatsoever for the academic character of an institution. Anyway, so that gives you a bit of an understanding of many of the important documents that are involved in the arbitration decision. We looked at one set which had to do with those 4 levels and the documents that pertain to those 4 levels. The most significant being the final submissions of MRU and the MRFA. That's all available. The second post concerns the 3 excerpts that I have provided of the arbitration decision concerning the suspension, the termination, and then the arbitrator's decision not to reinstate me. And what I've done is I've just provided screen captures of those very, very important areas so that people can get a sense of the kind of reasoning that the arbitrator was using and why that reasoning appears to be flawed. Anyway, this will be the subject of an appeal, but since this decision has been released to the public, I think it's very, very important to be able to communicate about it so that I can respond to some of what I think is quite makes it very difficult for me to convince people that, you know, I really didn't. This case is just seems to me to be completely unjust and rewards activities that, if it continues, will result in the destruction of MRU as an academic institution. Thank you very much for listening. I hope you found this video to be helpful in understanding the arbitration decision.